to be with you today. We have a really interesting episode, a really interesting conversation about to take place. But first, I want to talk to you about Calvin McNeil. So when Calvin McNeil was 16 years old, he robbed a dice game with some of his friends in Baltimore. What they'd hoped would be just a simple shakedown went sideways, turned violent, and McNeil ended up shooting and killing a man. McNeil was convicted of felony murder and sentenced to life in prison. Now, that was back in 1981. He was 16 years old. And for the next 4 decades after that night, McNeil was incarcerated at Jessup Correctional Institution in Maryland, working for a second chance. And I really do mean working for. He was not just passing the time. All signs suggested that he was doing everything he could to prove himself worthy of a second chance. So he went, I will tell you this, more about 25 years without a single infraction. Something I can tell you based on my practice as a criminal defense lawyer is basically impossible, because you can get an infraction for like cutting your pants into shorts if you're in prison. So he went 25 years with no infractions. Beyond just not making any mistakes, he championed anti-violence work. He earned numerous commendations from prison staff. But every time he would come up for parole and the Maryland Parole Commission would recommend him for clemency, I apologize, not come up for parole. Every time the Maryland Parole Commission recommended him for clemency, multiple times over the last 12 years, the governor would deny him release every single time. Like tens of thousands of others who are facing extreme prison sentences, including many who got life sentences for things they did when they were children, it seemed that the system, in this case at the direction of Maryland Governor Larry Hogan, was intent on leaving Mr. McNeil to rot in prison forever. Now, Mr. McNeil is not alone. Under the extreme sentencing practices of the 1980s and 1990s, many of which still persist today, prosecutors and judges around the country have managed to lock up thousands and thousands and thousands and thousands of people in a way that essentially throws away the keys. These excessive sentences are, I will tell you, not effective for public safety. One of the nice things about this field is there is research. There are scientists who study what works and what doesn't work in terms of public safety. So we actually know that when you want to deter somebody from doing something wrong, what works is the certainty of the sentence. A certainty of a 6-month sentence is actually a better deterrent than the possibility of a life sentence. People don't respond to the severity of the sentence. They respond to the certainty of it. So we're not doing something that works with these long sentences. This is not good for public safety. It's not good for anybody. And like many impacts of this system, perhaps all impacts of the system, it disproportionately impacts people of color, specifically Black men. But one thing that this wave of life sentences has accomplished is to make the incarcerated population boom. And it has made the population of people behind bars older and sicker and more costly to care for. Between 1993 and today, the number of elderly people in state prison increased by 400%. There are now around 200,000 people who are 55 or older incarcerated in America. And most of them, like Calvin McNeil, have been incarcerated for decades. And many are facing the possibility of dying in prison for things they did when they were kids. So the truth is that the vast majority of these people that we're talking about today should not be in prison. Studies have shown, again, we can rely on science. The problem with criminal justice isn't that we don't have science, it's that we don't listen to the science. So studies have shown that elderly people are really low risk to release. So they don't have any substantial risk of engaging in new crimes if you release them. It is very safe to release elderly people. And with COVID continuing to rip through prisons, keeping so many elderly people and people with pre-existing conditions, sick people who need better medical care, we are sentencing some of those people to death behind bars. Since the beginning of the pandemic, more than 200,000 people have been infected with COVID-19 in prison, and more than 1,500 people have died of COVID in prison around the country. That's according to the Marshall Project's research. Mr. McNeil could very well have been the latest to suffer this cruel fate. if not for the recent intervention of Baltimore City State's Attorney Marilyn Mosby. So last year, the state's attorney's office agreed to review Mr. McNeil's case. And based on his conduct in prison, his remorse, his re-entry plan, the length of time he served, all of these factors about who he really is as a person, Mosby's office determined that McNeil could be released. And on July 6th, a judge ordered Mr. McNeil freed after nearly 40 years in prison. So that's the sort of area we're going to focus on today. We got some good news this week that ensures that Mr. McNeil is not going to be the last person to receive this kind of reprieve. State's Attorney Mosby and newly elected LA County District Attorney George Gascon have announced the creation of new sentencing review units that are expressly dedicated to this kind of work, the kind of work that freed Calvin McNeil. Los Angeles and Baltimore are going to join a handful of prosecutors' offices around the country that have created these sentencing review units to provide relief to people who don't need to be in prison, especially juvenile lifers like Mr. McNeil. So this is trailblazing stuff. It's really cool. This is a conversation we're so excited to have. We've got State's Attorney Mosby here with us today. We've got sworn in yesterday, DA George Gascon here with us today. So excited to welcome you both to the show and to talk about this incredibly exciting subject matter. Thank you both so much for being here.
Thank you for having us.
So State's Attorney Mosby, I'd like to start with you. I'm hoping you could actually just kind of talk to us for a minute about Calvin McNeil and why it was so difficult to get him released in the first place. He sounds like he had this slam dunk case for release. What was wrong with everybody else in the system that it took so long to get him relief?
So, Emily, I would say that you've touched upon it. I mean, despite being recommended for release by the Maryland Parole Commission 3 times, right, in the past decade, each time he was recommended, he was denied by a sitting Maryland governor, despite his stellar sort of incarceration record. And rehabilitation and means of rehabilitation that he clearly displayed, all because Maryland is one of only 3 states that requires approval from the governor as part of the parole process. And so, as you indicated, last year, the ACLU of Maryland brought the case to my office's attention, and after assessing numerous factors, which was inclusive of the facts of the case, the mitigating circumstances, the changes in sentencing practices, right, from then, 39 years ago, a year when I was born, right, I was 1 year old when this took place, his conduct while incarcerated, his re-entry plan, his age, medical conditions, his remorse, positive development, his community connections, we joined a defense motion to modify his sentence, and he was ultimately released. Now, this is 39 years later. He committed this offense when he was 16. He's now 56 years old. And so Mr. McNeil, the irony of all of this is that Mr. McNeil is just one of many stories, right? Juvenile lifers and elderly people facing excessive sentences that have left them with the prospect of dying in the prison or never being able to be given that second chance to prove themselves as productive members of society. Right now, Mr. McNeil is working with his brother, and he wasn't at the press conference last night because he's working with his brother, right? Like in the community. And the fact of the matter is everything that you've already brought up, like that people who are, these are the individuals who are more sickly, the cost to incarcerate these types of individuals, these elderly individuals, they're not a threat to public safety. The research and science has told us that they age out of crime. And most importantly to me is that these excessive sentences have been disproportionately imposed upon Black people. When we look at the United States as a world outlier, the state of Maryland is an outlier in the nation, right? When we talk about the more than 2,000 individuals that have been imposed upon life sentences, it's crazy because African Americans make up 30%, only 30%, a mere 30% of the state population, but 70% of the prison population. Those that are imposed upon life, those over 2,200 individuals, almost 80%, that means 8 out of 10 of those that are imposed upon life sentences are Black people. And in the city of Baltimore, they're 94%, where those sentences were imposed. And so that disproportionality is something that you have to consider, especially in light of the fact that prosecutors have historically and contributed to the epidemic of mass incarceration and racial inequity. We also have a responsibility to end that, which is why I launched the sentencing review unit in my office.
I love that framing of taking responsibility to undo some of the damage that has been done. And I want to turn to you, DA Gascon, because California, I often think of California as like a pretty lefty state with like deep South incarceration problems. It has a unique relationship with incarceration that a lot of people don't realize. And it makes the sort of sentencing review commission that you've committed to such a critical initiative. So I'm hoping you could talk us through kind of the background of extremely long sentences in California and explain how it guided your decision to create this new unit in your office.
Yeah, so Emily, much like Marilyn, talk about the experiences she's had in Baltimore. If you look at the trajectory of mass incarceration in California, which, by the way, California sort of led the nation, as it often does, for good or bad. In the 1980s, we had about 23,000 people in state prison. And then we began the era of, tough on crime policies. And by 1990, that number had grown to about 90,000 people. And then we, in 1994, we imposed 3 strikes. And then 6 years later, we had 160,000 people in prison on a system that, even after we built 22 prisons, which we then did in a short period of time, was only rated for about 120,000 inmates at any given time. So what you see was this ballooning of incarceration with no proportionality to public safety or crime increases. And of course, much like it occurred in Maryland and the rest of the nation, the representation of the people that are going to prison was disproportionately African-American. In our case, the state of California, African Americans are 6% of the population, and you see this disproportionality. In fact, people that are doing life without the possibility of parole out of LA County, somewhere around 75–80% happen to be Black. Now, of course, LA County, because it is the largest county, not only in the country and the state, is so huge. We have over 10 million people. About a third of all the people that go to state prison come from LA County. So in looking at resentencing, just following the guidelines that very much what Maryland is doing, when we're looking at people that have been in prison for over 20 years, we're looking at the age of the individual because we have a lot of seniors that are in prison. We look at people that were incarcerated when they were a kid, they were under 18. We look at the health risk factors in terms of COVID, or we look at the rating actually that is given by the corrections department and parole as to the likelihood of reoffending. For instance, we find out that people that have been in prison for over 20 years are rated as, 95% of them will be safe to be released. So why are we holding this? So in the case of LA County, we're looking at somewhere between 20 and 30,000, 20 on the low end, 30,000 on the high end of people that can be resentenced, and many of those would be released. And basically the sort of the yardstick that we're using is we're saying we would look at it, if we would sentence you differently today, we want to make whatever we're doing today retroactive to when they were brought into the system. So we're creating a unit to begin to do that work. We're also going to stop attending parole hearings. Frankly, we see especially LA County has been a very strong practice of opposing every parole release. So, people are coming in front of the parole board every day, frankly, with a recommendation from the prison system to have that person released. And, and there will be an LA County district attorney, their assistant district attorney, opposing the release and sort of relitigating a case that occurred 20, 30, 40 years ago, as if the person would be still the same person that committed the crime. And, I often tell, in fact, I was telling some of my DAs yesterday, I said, how many of you are the same person today that you were 40 years ago? And of course, some of them weren't even born. But, it's just, it really speaks to the incongruity that we We litigate a case decades ago, and then we go back and keep relitigating that case and keeping that person locked up, much like the example that Maryland just brought up, where the governor keeps denying parole, someone that has been a model prisoner, has been in prison for, nearly 40 years. It makes no social sense. It makes no public safety sense. And then economically, it's just, it's horrendously expensive. And that money should be going into social services, education, health services. We are estimating that the release that will come from LA County will more than likely save the state in the low end multiple billions of dollars state budget. So that's how much money we're talking about.
So it sounds like this is sort of like a riff on some of the funding reallocation arguments that we've heard, which is taking money away from lengthy sentences and rerouting it towards front end, education and other safety net things. I want to dig into that in a second, but before I do, so you've both described kind of complementary but slightly different models, it sounds like, because D'Agostino, it sounds like your unit is happening in harmony with a litany of other reforms that you're trying to make fairly apply to people, regardless of when they were sentenced.
Right.
Which has always been one of my big concerns. When we get this great reform in the law, it's super unfair that only applies to people going forward. Like, why would that not apply to the people who were already negatively impacted? State's Attorney Mosby, it sounds like you're also very focused on finding meritorious cases, but it's less about harmonizing a new policy initiative and more about undoing some of these very, very egregious cases from the past. So I'd love to hear, I think one of the questions that our viewers probably have is like, how you each are going to make sure this works functionally, like D'Agostino, how you're going to get to those 20,000 people. State's Attorney Mosby, how you're finding the people for your office's review unit. So I'm hoping, starting with State's Attorney Mosby and then moving to D'Agostino, I'm hoping you could just tell us exactly how you're finding the people, what the relief process looks like, and how you're going to make sure that this momentum keeps going and that these people actually come home.
So, and I appreciate your question. One of the things that we had to do in understanding and recognizing that we have to retroactively kind of correct the wrongs of the past is that we had to set a criteria. And right now, there is no sort of legal mechanism for us in the state of Maryland. For the past 2 years, we've been pushing this second look back bill legislatively that would allow us to go in as a prosecutor and to give defendants and inmates the opportunity when they are imposed a life sentence. After serving 25 years, they are given the opportunity to receive a hearing, right? And to consider several factors as to whether or not that person has been rehabilitated. I've gone down to Annapolis, testified on that bill. I intend to do so. Until that takes place, one of the things that we've been able to do is to utilize our legal mechanisms that are at our disposal. And what we know about the COVID situation, right? Our Chief Judge Barbera has put out an order that basically says that we as stakeholders in the criminal justice system need to consider the vulnerabilities of those that are more susceptible to the COVID virus, right? And so when we look at what COVID has done, that the stakes have increased significantly, right? With this, especially the second round of COVID cases. And we have to keep in mind that our jails and our prisons still remain a public health risk and a breeding ground for COVID-19 that imperils not only the individuals that work in those facilities or that are housed in those facilities, but the broader community. And the other sort of issue that is at bay is that COVID-19 has proven to be a crisis for the criminal justice system overall, largely in part because of the pre-existing sort of dreadful stain of mass incarceration. Right. And in this country where these conditions are unsanitary, there's overcrowding, there's quite frankly dehumanizing conditions of confinement. And so we have to be able to put ourselves in a position where we can reduce that threat of COVID-19 and the amount of local precious resources that are spent on incarceration by doing what many other cities. You have George on the line right now and myself, and many other cities that understand and recognize that we have to release those individuals that pose no public safety risk. And so when you look at Prince George's County, Aisha Braveboy in the state of Maryland, you look at, Dan Satterberg, Larry Krasner, Chester Boudin's office, Eric Gonzalez's offices, and now George Gascon. This is what we're attempting to do. And more importantly, I think it's really, really it's incredibly important for us to really understand how we got in this position. And when we talk about like a state like Maryland, right, with juvenile lifers, who we all recognize and accept that when it comes to juveniles, the science tells us that we should treat them differently than adults. However, in the state of Maryland, because of politics, juvenile lifers have effectively become juvenile lifers without the possibility of parole, which is in total contradiction to the Supreme Court, right? In 2016, they have come out and said that if you're a juvenile, you cannot do that. You cannot, in essence, sentence a juvenile with the possibility to life without the possibility of parole. 23 states across the nation have banned juvenile life without the possibility of parole. What you did at 16, right, should not always define who you are at 70. And so what we're recognizing is that there are over 300 juvenile lifers in the state of Maryland, 200 that are parole eligible. But because of the history of politics in my state, right, in 1995, the then Governor Glenn Denning came out and removed pre-release of all lifers in correctional facilities when he had his famous
I want to actually get into the juvenile thing and the sort of proactive going forward thing. And before we do, I want to let DA Gascon answer just functionally how these folks get before his office. And then I want to come back to you to sort of dig into what you're saying about kids. Well, I want to talk about kids, but first let's move to DA Gascon for 1 second to talk about how he's going to find these 20,000 people or more.
Yeah, so in California, we're fortunate enough that we've had a series of criminal justice reform legislation that's passed by both the voters and the legislative, the California legislation. So we now have a vehicle where people that were sentenced and then they had their base sentence and then they had the enhancements. If they have completed the base sentence, they may qualify for resentencing. So it's given us an opportunity for people that frankly sometimes are being given a base sentence of say 7 or 10 years, and then the enhancements takes it up to 30 or 40, to be able to say if they already completed their base sentence and assuming that they're, that the corrections department believes that these are people that are eligible to be released, that they can be released safely.
Thank you for that. I love the very tactical play-by-play of who is involved and what do they have to do. So that's really helpful. Okay, so going back for a second to the question of kids. I kind of want to hear from you both about this and a broader iteration of it, which is, as we're talking about undoing the wrongs of the past, I think you've both expressed a view that this has to be done in concert with a different way of practicing as a prosecutor going forward, a different way of reacting to who is the community you're protecting, what does safety look like? And so I'd love for you to spend a moment talking about, DA Gascon, in your absolute mic drop of a policy litany that you posted last night, you mentioned, not prosecuting kids as adults anymore, and a whole host of other reforms that it seems like are in concert with the sentencing review conversation. So I'd love, starting with you, DA Gascon, and then moving to you, State's Attorney Mosby, to just hear about where this work fits in terms of proactive policy moving forward, and other sort of initiatives to set people free, just generally how this fits into the bigger picture of your work.
Right. So, I mean, first of all, obviously, we don't want to keep putting people in the pipeline. So it's really important that proactively, as of today, actually, that we are not seeking any longer a series of types of activities. So we're not seeking the death penalty anymore, which LA County, by the way, put 23 on death row in the last 7 years, more than Georgia, Louisiana, Virginia, and I forget one other southern state, which is insane. So we stopped that. Now, obviously, we have people that are in the current track for the death penalty, right? There are different stages of litigation. So we have to then go back to the courts and sort of get those people out of that track. And then finally, we have people that are already in death row, and that will be yet another procedural process. The same thing with juveniles, right? We have juveniles that are currently, well, first of all, we want to make sure we don't put any juveniles today into the adult system. So that's the first thing. Then we have juveniles that are currently in different stages of litigation as an adult. And in those cases, we're going to have to actually go back to the courts and their new procedures in California. In order for a juvenile to be referred to adult court, they had to be a court order. So a judge had to agree with the prosecutor and put the, being the juvenile unfit to stay in the juvenile system. So now we're going to have to go back to those judges and say, guess what? We want you to rescind that and put this kid back into the juvenile system. And obviously that's going to require litigation in many cases. And then we have to look at the kids that are already in adult prison and start to rewind those and try to bring it back into the juvenile system where we can. Sometimes, frankly, they have been in there for decades. So each of those processes will be different. Obviously, the prospective work of stop sending people is the easiest one. We just simply say you won't do it anymore. Then you start getting into different stages of litigation and procedural complexities to deal with the rest.
So State's Attorney Mosby, how does that, I'm interested to hear actually how your position differs, if at all, from DA Gascon's position, especially with regard to not prosecuting kids as adults, and what other sort of forward-looking policy initiatives fit in with your resentencing work?
So the one thing I can say, and I didn't get an opportunity to talk about what the criteria is for the sentencing review. I think it's important to set out what that is. The initial review is not wholly sufficient for recommendation to support release. However, we have set out individuals who have a documented sort of medical condition as defined by the CDC that places them at higher risk of illness or death in contracting COVID-19. That's our legal mechanism by which we can go forward with those types of cases. And it's individuals over the age of 60, right, who have spent more than 25 years on a life sentence, or juvenile lifers that have spent more than 25 years on a life sentence. And so, in addition to those various other factors that we considered in Mr. McNeil's case, that is what is going to help us arrive at the recommendation as to whether or not someone can actually be released. And when we talk about going beyond this sort of retroactive intervention that you all were just discussing with proactive steps to address the extreme sentencing, some of the things that we've attempted to do is, one, I think that it's incredibly important for us to remain vigilant about legislative sort of proposals that impose tougher sentences, right? And I created a policy and legislative affairs team. We track these types of laws that are coming into existence. For example, the imposition of mandatory minimums in the state of Maryland on guns and drugs, right? We were in opposition to that. One of the things that I've had to fight against, and I'm sure that George will run up against this, is that, not only did we have a federal administration that was resistant to progressive prosecution, but locally, we often have, legislators and governors that try and take away our power because they feel as if we are not being tough enough and imposing stiff enough penalties on individuals. And so what I would say is that, especially during COVID, being proactive in not allowing people to get into the system to prevent them from getting in the criminal justice system is incredibly important for prosecutors. And what we've done in Baltimore City is that we've not only been able to reduce and decrease the jail population by more than 45% from last year as a direct result of our proactive steps in saying, when it comes to prostitution, when it comes to drug possession, when it comes to disorderly conduct, we are not prosecuting these types of cases, right? And despite the police commissioner, I've worked with 5 years, but the current commissioner who's like, okay, we're gonna continue to arrest. No, we're not, because even if you arrest, we're gonna release without charges. And what that has allowed us to do is that we've been able to decrease, and they have conformed, the police department have now conformed. We've been able to decrease the arrests by 75%, right, when it comes to drug possession cases. And so being proactive is not just a matter of sentencing, because we're the ones that make those recommendations and we need to be cognizant of the recommendations that we make, but on the front end, ensuring that we're not allowing these low-level offenses that have nothing to do with public safety to allow individuals that are being disproportionately impacted to come into the criminal justice system in the first place.
Absolutely.
So I want to give you each a time. We're at the top of the hour, but I want to give you each a moment because this is such an important policy piece. And I know you are both in an environment where you are doing something pioneering and new and challenging. So I want to give you each a moment to, if there's any final points that you want our viewers to know about what you're working on. State's Attorney Mosby, we'll start with you, and then DA Gascon, you'll have the last word in celebration of getting sworn in yesterday. You get the last word on just any further things about this work that you'd like to communicate.
So the one thing I will just say is that, almost like the marijuana policy that we introduced, we have one of the most progressive marijuana policies in the country in January 2019, where we, in essence, don't prosecute marijuana regardless of weight, regardless of, criminal history of that individual, because there's no public safety value. It's counterproductive to the limited resources that we have, and it's discriminately enforced. It's the same situation with these excessive sentences. Right? There's no public safety value in ensuring that we're, in essence, keeping individuals that are elderly incarcerated. There's no public safety risk. That's one. It's counterproductive at a time during COVID when we have got to ensure that we are prioritizing our resources. Taxpayers are paying for these elderly inmates, and it comes at a cost. $1 million, according to the Sentencing Project, $1 million per prisoner a year. And it's extremely cost exorbitant. And then I would just say that, we should ensure that when it comes to, public safety, redefining what that looks like, that's not 60-year-olds. That's not individuals that have been incarcerated for 40 years for a crime that they committed when they were 16. When it comes to ensuring and not being complicit in the discriminatory enforcement of laws, right, and sentencing, that's recognizing that as a prosecutor, we have helped create this epidemic of mass incarceration and racial inequality, and we have a responsibility to rectify it. And so that's what we're attempting to do through these sentencing review units.
Thanks so much. DA Gascon, let's close out the show.
Yeah, no, so I think first of all, I think it's really important, and Marilyn touched upon it, that what we're doing actually is better for community safety. Actually, the era of mass incarceration also had recidivism rates that, in many communities get as high as 70%, certainly in the 60 percentile, which means that people that are being arrested and being convicted and incarcerated, they come back and they harm themselves and they harm others, right? And that is not the norm around the world, right? We have other communities where recidivism rates are much lower, and we know, and there is data and science to support that. Actually, as you talked earlier, certainty of intervention, the quality of intervention, the rehabilitative steps that we take are actually more likely to make us safer than just simply locking somebody up for a long period of time, or quite frankly, locking up someone at all, especially in many of the low-level offenses that we have seen so many people incarcerated. So I think that what is really important is to redefine the whole concept of how do we get to community safety. We have to take that away from the people that have profited from higher levels of incarceration, private prisons, prison guards, police unions, and really have a different conversation. Because what I see, in fact, in my own community, yesterday, the police union, one of the police unions, because I have 45 police departments, one of them came out and said, well, now the gang members are going to be the ones that are going to benefit from this, and, public safety is going to go to hell. And I'm saying, well, wait a minute, you've had a 27% increase in violent crime in the last 7 years, locking all these people up, right? What is it then that you did before? Because certainly what you did before wasn't working, so how can you now blame me for this and say that this is going to be somehow unsafe? So we just have to really push back and educate the public and say, what we're doing actually is going to make us safer. California, 1980, 23,000 prisoners. 1999, 160,000, right? And our crime picture is not necessarily any different. So we just have to re-educate people. And unfortunately, because we have generations of people that were born and raised under the belief that, oppressive policing and incarceration and prosecution was the answer to safety, instead of saying education, housing, public health, all the other verticals that are more likely to create a more sustainable and healthier community. So I think we're going to have to work really hard to not only reshape the policy within our office and our community, but really educating the public as well.
I love the sort of holistic viewpoint of thinking about all of the other sort of ropes in the social safety net that are more important for public safety than traumatizing and re-traumatizing people in a carceral space. So thank you both so much for joining us here today on the Appeal Live. It's been an absolute pleasure speaking with you. I hope to speak with you many, many, many times again in the future as you continue this tremendously exciting work. My name is Emily Galvan-Almanza. This has been the Appeal Live. We're going to be back on actually at 1:30, talking about the coming wave of evictions that's set to magnify America's COVID-19 crisis, speaking of the social safety net. So we hope you'll join us back here at 1:30 p.m. Eastern. We'll see you soon. Thanks again. Take care.